Some of you may wonder why on earth I'm doing this today, and even more would ask, why on earth would I spend thousands of hours fighting a lawsuit in 4 different courts, state and federal, and dealing with 8 appeals by the other side, all of which we won, but for 14 years. And I made that remark to somebody one time, and they said, well, Gene, you remind me of an oak tree. I said, what? They said, an oak tree. I said, what are you talking about? He said, yeah, an oak tree. Once was a little nut that just wouldn't give up. So I think I appreciate the analogy. I'm not sure. I like the first part. Well, I guess the last part's true too. But the question that is so obvious, is there anyone in this audience, or I could go out on the sidewalk and ask the same question, is there anyone who's never had either a lie told to you, and there's 2 different things, or a lie told about you? Either way, it's wrong. It's wrong in many respects. And I like what you've probably seen the board, what Friedrich Nietzsche said 127 years ago about the lie. And he said, I'm not upset that you lied to me. What I'm upset about is that from now on, I cannot believe you. And isn't that true? And isn't that what we have as a practical matter? And is that not what we have going on in politics on and on and on 14 years ago, before then? And that's what we're having now, and that's what we're having, the problem we're going to have in the future. How can you possibly believe somebody that has once lied to you about something important, something substantial, something that affects your life, your family, something that affects our government, your government, my government? It's pretty important to know the truth. And stop a second or two and think about what's going on right now. Are we still being lied to? Well, there's a lot on television that convinces me that the problem is with us today. But my concern here is not so much when it happens to you, but most people have agreed with me, it's pretty hard to get over it. It's pretty hard to forget the barefaced falsehood told either to you or about you, because it's wrong. And my concern here has been more than just a lie about me. I can stand it. That's not that big a deal. Even about my children and my family, lying about them and their integrity. That's pretty bad. Lying about a person's trade and business, how they make a living. That's not good. It's awful. It's a violation of many things, which I'll talk about. Not just a lawsuit for slander. That's just one thing that's wrong about it. The concern to me that I would emphasize today is not the personal aspect of it, but what negative advertising has done and what it is obviously now continuing to do to our political system and in the operation of our government. They talk about the government spending, the politicians spending government money. There's no such thing as government money. It's our money. It's the taxpayers' money. The government's not a profit maker. It doesn't own a thing. It doesn't have anything, but it controls it. And for it to control things like expenditures and our money through the process of not telling us the truth about it is really what motivates me to be here with you today. And the political consultants that I've talked to, on both sides of the political fence, they will quickly admit that lies in political ads are used because it works. The politician, they advertise most of the time the lie, the negative ad, the attack ad will come at the last minute to the detriment of the other side, who will either mainly not have time to respond appropriately to the ad, but also to have as much money as is spent, as in this case, $1.2 million on this particular ad, having that much money the last few days before the election, not even Ross Perot or Warren Buffett probably wouldn't be ready to do that. It wouldn't be enough time, even though they'd have the money. So in the Boyce and Isley law firm case, which is what this is about, the political opponents started this plan and this plot long before the TV ad, long before November, the last week before the election. It was started 6 months before, and you'll see some more evidence of this, in a push poll. I'm sure you all know what push polls are. You've got on your home phone more than you care to. And the push poll was the same words that ultimately came out 6 months later on the TV ad. And the push poll was by telephone, was done to 800 people. I wouldn't have this information were it not for the process in litigation of what's called pretrial discovery. About 90% of what you will hear me talk about is evidence that comes from the other side, not voluntarily, but through the pretrial discovery process that gave me and my family and my law firm the opportunity to demand that the other people disclose relevant evidence, and that's what happened. So the evidence will show that the push poll, 80% of the people said they would not vote. It would be highly unlikely that they would vote for Dan Boyce for public office, having made this accusation that he charged his law firm, sued the state, charging $28,000 an hour in lawyers' fees. Now, that's no surprise. I'm sure there were even 20% that had some doubt and said, well, we don't know. We don't know enough. But 80% of the people in June of 2000 said, oh, heck no, we wouldn't. And neither would I, neither would you. But that gave that planted the seed in the opponent's mind and in the consultant's mind that particular accusation, not true, but that accusation would work politically. And so in November of actually Halloween night of all times, this ad began to run on many TV stations for at least three times a day, and for certainly 7 days and nights it ran on TV. I'll get to the substance of that and the meaning of that in a little bit. It's one thing, some of the slander cases have involved a store clerk that was talking to another customer, and a lady came by and the store clerk said something slanderous to this one other person about that lady and her character. And that developed many years ago into a slander lawsuit. And that's one thing, a lie told published to just one other person is wrong. But you will see in a little bit how many other people this ad was sent to, and how many people the opponents in the election wanted, how many people they wanted to hear and to believe what I will show you. The evidence is pretty solid. It's a flat 100% lie. Not just one lie, but the ad is full of lies. Just a quick example. For example, Dan Boyce, his law firm sued the state. That's a lie. It's not slanderous, but it's wrong. It's a lie. Dan Boyce's law firm never sued the state. The law firm, as you'll hear and see, was a law firm out of Winston-Salem, Will Carlisle, Sanders and Rice, a big law firm that I was associated with for a period of time. And Womble and myself and a couple of other lawyers in that firm, we were the ones that brought this lawsuit that's specifically identified here as case number 95 CVS 6715. That lawsuit started in 1995, and you'll hear a little bit more about it. It was concluded in September of 97, and Dan Boyce and the Boyce law firm, Boyce and Isley, was not even informed. It didn't even exist until July of 1999. That's just one example. But libel and slander, you understand, I'm sure, but the libel and slander consist of, in politics particularly, doing something that is wrong in many ways. It's not bad just to say something's wrong, but it's wrong civilly. That's what a libel lawsuit is about. But it's also a crime. The North Carolina law says it is a misdemeanor to publish an ad, and this is the 1937 Corrupt Campaign Activities Act that not many people know about, but it says it is not only wrong civilly, it is a criminal act to knowingly publish a false, it's called a report in the law, but a false statement in a political campaign. There are many things wrong about this type of conduct, not just violation of a statute civilly, violation of a statute criminally. It is also, in North Carolina, it is also an unfair trade practice. If somebody tells a lie about your trade or your business or your profession or your occupation, that is a separate offense called unfair and deceptive trade practice under Chapter 75 of the North Carolina law. In addition to that, lest we forget, it's a pretty basic violation of the Ninth Commandment, bearing false witness against your neighbor. That's basic, that's wrong. That punishment will not come from the criminal court. That punishment will not come from the civil court. That punishment for that wrong will come from somewhere else, as it should. This fight, you'll see the wrong here focuses on that 1997 lawsuit, because that's the only way they could tie their opponent, Dan, my son, in, is because I, along with another law firm, the big firm out of Winston, was involved in that case. So there was no involvement in the case by our little old law firm in 1997 because it didn't exist. And Laura, my daughter, and my son-in-law Philip, Isley, and Dan, it was just four of us, and I had something to do with it, but it was all over with. And in the how it all came about, this case, it involved the taxpayers, as in the ad, charged $28,000 to taxpayers. The deceit in that is the opponent, Cooper, wanted you all and all the voters to believe that all of you taxpayers were being charged money. Well, forget the $28,000 an hour, but the only people that could have been charged were not all the taxpayers. It was just a group of 172,000 taxpayers, of which Mr. Latta, who we'll hear from in a minute, was one of four people who came to me in the spring of '95 and got all this started. The taxpayers was a limited group, a large part, but not all taxpayers, of about 200,000 people who had been paying intangible tax on stock, bank accounts, money market accounts, intangible property since 1937. What happened in 1995, the Will Carlisle firm, not my firm, but the big firm out of Winston, had a client up in Salisbury. It was the Fulton Corporation of the family that made headache powder, I think it was. Anyway, they had a whole lot of stock. Most of the intangible taxpayers were small people who had paid $100, $300, $400 in taxes. The wealthier taxpayers that owned big North Carolina corporations, they had a lot at stake. So this one family brought suit, paid Will Carlisle by the hour to test the legality of the tax. The case in 1995 went through the courts. The trial court said it's okay. Our Court of Appeals said no, it's illegal. And then our Supreme Court said no, Court of Appeals, you're wrong, it's okay. And that's what the status was in 1995. Well, I was busy in 1995 with the Bailey trial in March, and it continued on through September. And I was involved in the Falconberry case, which was the 6,000 disabled retirees who were being cheated. And I tried that case before Judge Cashel in April. But in that period of time, when the U.S. Supreme Court took the Fulton case and said, we're going to look at it, well, that was blowing a big whistle. When the U.S. Supreme Court says they'll take a case for review, they don't have to review any case. It's voluntary on their part. But when in February of 1995, the U.S. Supreme Court said, we're going to look at this Fulton case and we're going to look at this North Carolina intangibles case and determine whether it's legal or illegal. Well, that was blowing a big whistle to my friend Mike Latta and to Judge Smith and to Reed Control, another friend, and a fourth friend who's no longer with us, bless his heart, Chris Coley. Those four guys came to me and said, you got to help us. Well, I said, you know, in April when the U.S. Supreme Court said we're going to determine validity or invalidity, they were stockholders. I didn't own any stock at that time, and still don't like it anyway, but some people in the stock market, and those four guys, they didn't have much money, a couple of $100 refunds at stake, but they were the kind of people that stood up to what they thought was wrong. And so they came and said, Gene, you gotta help us. I said, what are you talking about? They said, you gotta file suit. I said, well, what's the big rush? I'm busy. They said, the statute of limitations is running. If the tax is illegal, every year that passes while the courts are dealing with own and own and own and own, only 3 years can we recover. And if you don't file suit within 90 days, the law says, by July 15th, after April 15th, we lose a year of our taxes. And they were about to lose, I think it's about $300 or $400, not even that much, a couple of $100 apiece. But they saw the principle involved, and when they filed, that protected over 200,000 other people, because the law says when an action is brought by one person, and there are others similarly situated, that stops the running of the statute of limitations. So they were not only doing it for themselves, they were not only doing it because it was wrong, they were doing it to stop the statute of limitations from running against 200,000 other people. 199,900 they didn't even know, but they were doing a service to all the other stockholders pending the decision in the U.S. Supreme Court. I said, I'm kind of busy, and they were close friends. So 6 days before the statute ran on July the 15th, on July the 9th, I filed this lawsuit, 1995-6715, on behalf of these four friends of mine. There was nothing else that needed to be done then, because the Fulton case was then in Washington before the U.S. Supreme Court to decide if the tax was legal or illegal, constitutional or unconstitutional. And until that Supreme Court decided, there was nothing to do but sit and wait. And that's exactly what happened. I tried these other cases that Becky mentioned and was busy on a lot of other things. In October of 1995, that fall, there was a hearing in Washington before the U.S. Supreme Court, and I attended the hearing along with a couple of clients just to see what Womble's lawyer that was handling it, I was not involved in the Fulton case, what the U.S. Supreme Court might do. They received the case, they received the argument. In October of 95, nothing else happened. In February of 1996, the United States Supreme Court issued its decision in the single taxpayer case, Fulton. The U.S. Supreme Court said, North Carolina, your tax is illegal. You cannot impose a tax on just North Carolina stock and not impose the tax on all stock. That's discriminatory. And to some reasonably great surprise, the taxpayer in that case won. When that taxpayer won, so did Mike and Donnie and Chris and Reed, and so did 200,000 other taxpayers won. So the U.S. Supreme Court sent the case back to North Carolina in February of 1996. The case, there's nothing the Supreme Court of North Carolina had to do but to tell the government, tell the legislature, you got to solve the problem. it's illegal, you got to correct it. It gave them 3 choices of ways to correct it. One of the choices politically was not satisfactory with the group of politicians over in our legislature. They adopted the 3rd choice of simply repealing the tax because it's illegal and refunding the money to those people. The legislature sat and waited. The Supreme Court of North Carolina kept that case from February of 1996 all the way to February of 1997 when it told the legislature, correct the problem. The tax is illegal, repeal it or change it, make it legal, or refund the money. Our friends in the legislature made the decision of those three choices. We're going to refund the money. We're going to repeal this tax. It had been an unpopular tax for years and years and years. I've got a lot of information about how controversial that tax was in the overall scheme of things. So the legislature, maybe with some political thinking about it, repealed the tax and ordered that it be refunded. At that point, Mike's case and Judge Smith had been made a class action by Judge Manning, to whom the case had been assigned to. The 2067-15 case had been assigned to Judge Howdy Manning here in Raleigh. And he had made it he had determined it was a class action because not just 4 people, but it involved the legal rights and constitutional rights of a whole bunch of people. So it became a class action. That's a different type of action. It's frowned upon by a lot of people because it always involves a lot of issues. It involves a lot of money, and it involves a lot of expense, and it can involve fees, but only fees charged by the judge. Mike and Donnie and Reed and Chris had a contract on a contingency fee basis where if they won, Will Carlisle, that was the lawyer, including me and others, would get 20% of $100. So we get $20, and 4 of them that'd be $80. So they'd make a lot of money. And I'll switch forward. If Will Carlisle had lost this particular case that they were working on, Fulton paid a fee by the hour. But if it lost some of these other cases, Will Carlisle took the risk of handling them with me doing the work and would have lost over $2 million. That's what is involved in taking cases like this on a contingency fee on a risk basis. The lawyers, bless their hearts, there's some good lawyers, believe it or not, in this world. In fact, I told some people the other day that you all probably didn't know lawyers are buried 24 feet down in the ground, not 6 feet, 24 feet. It's way down deep. They're all good guys. Yeah, y'all caught that. Okay. Anyway, they work hard. There's some great people that they are frequently looked down upon because of other things. But let me get on to the point. Mr. Latta, if you'd come around and take the witness stand, I've just got a few questions I want to ask you. If you will, speak up loud. We don't have we do have a separate microphone, but we hadn't hooked it up yet. Your name is Everett M. Latta, is it? Dr. Latta?
That's correct.
Yes, and you're one of the 4 gentlemen who got on to me in the spring of 1995 and asked me to bring a case in your behalf.
I did indeed, sir.
And you were an intangible. You owned a little bit of stock.
I did.
And you had followed the Fulton case, knew what was going on.
Yes.
And you wanted to protect your legal rights and wanted to do it for yourself and for all the other people who had not come forward on their own. Is that correct?
That's correct.
And you knew you were involved in the Bailey case and had some involvement in the disabled retiree case. You knew I was busy working on it, but you will admit that you all kind of got on me to get on the ball and start that case, didn't you? Okay. And what I have said about the U.S. Supreme Court, though you followed all that, and so we had to wait until the U.S. Supreme Court ruled and then came forward. Let me ask you this. after all that was over with, were you around on the Halloween night of the year 2000?
I may have been, but I don't recall the issue you just described.
Yeah. Do you remember seeing an ad on TV that we've looked at here today?
I do remember seeing it.
And we've seen the actual TV ad. This is a printout of it. And it is a fact that you, on beginning Halloween night, you saw the ad once or twice, maybe more than that. And is there anything in this ad that you know personally is not true?
All of it's not true.
That's right. Well, Amaroy Cooper, our sponsor of the ad, that was true.
28,000.
But yeah, did Dan Boyce's law firm? It didn't represent you, ever did it, in 1995 or any other time in this case. And Dan Boyce, to your knowledge, never sued the state in this case, did he? And neither did his law firm of Boyce and Isley. And the main thing is the accusation that there was a charge of $28,000 an hour. That was false, was it not?
Absolutely.
Yeah. And so based on that, what was your personal reaction when you saw that ad? How did you feel about it?
I felt like it was a disservice to Dan Boyce, whom I happen to know through you, and I thought it was a lie.
Yeah.
That's not true in every regard.
And in the case, being a client and being active in the case, had you been aware of the fact of Judge Manning telling the taxpayers and telling the court and telling the newspapers about the case and what the facts were and what the truth was about it?
I was aware of it, and I've been refreshed since that time with my own files, and say with certainty that the judge put out notices.
That's what I want to ask you about. Will you tell this jury here what did Judge Manning on June the 30th of 1997 issue an order in which he said there will be no fees in this case?
I don't recall the specific date, but that is exactly what he said in principle, that there will be no fees in this case.
And there is there were written orders issued by Judge Manning that said what the truth was about the fees in the case. Is that correct?
Yes, it was.
And when the ad was running, the ad that you've testified about was running, is it not true that Judge Manning from the courthouse issued a statement in writing that was publicized telling the world that Will Carlisle was the law firm in that case, that Boyce and Isley, our little founder, did not even exist?
That is correct.
And back on June, that was when the ad was running in 2000. Back on June the 30th, 1997, when the legislature had repealed the tax and ordered refunds be paid, Judge Manning issued a written order saying exactly the words in writing: the court has further determined that the taxpayers would be paid exclusively by another method, not having nothing to do with the recovery in the case, and said, put another way, there will be no cost or attorney's fees deducted from the principal amount of the refunds. That was his order. And that order was sent to the Secretary of State, and the Secretary of State mailed it to was ordered to mail it to all of the taxpayers.
Was that to state or revenue?
As the Department of Revenue, State Department of Revenue. In addition to that, I found this only a couple of months ago. Judge Manning's order was published in the newspaper, was it not?
Yes.
And that publication in the newspaper after his order of June the 30th said exactly what his order was, in which he said, put another way, there will be no fees in this case. Again, I don't want to bore you all, but again in August of 1997, there was a final hearing in which Judge Manning ordered that you all be paid your refunds in full, no fees, in September. And then on August the 14th, he published for the third time an order saying expressly there will be no fees. Not $28,000 an hour, not $2,800 an hour, not $280, not 28 cents an hour. The judge said publicly there will be no fees. The question then is, why did Cooper and his followers, why would they say something like this? Didn't they know? Didn't they follow the ads? Cooper was a member of the legislature. They were the ones that dealt with it. They're the ones that repealed the tax. They were the ones that ordered the refunds, and he was on the judiciary, on the committee that dealt with taxes. So he's bound to have known what the truth is, wasn't he? It seemed like that was a pretty good conclusion for somebody to reach. In addition to that, in the discovery process, guess who Will Carlisle's, including me, guess who some of our clients were that were taxpayers? Roy Cooper himself was a client. Family members were clients. Some of his lawyers in the case were clients of Will Carlisle and me. And they published an ad saying, in effect, they were charged not just a fee, but $28,000 an hour. What difference does that make? The difference it makes to a lawyer to do something like that, you can have your license taken away. It is a direct violation of the rules of ethics for lawyers to charge an excessive fee. And I don't think there's anybody on the face of this earth that would dispute the fact that the television political ad accused lawyers of charging an excessive fee. And if that were the truth, it would be devastating, and was not only to their business and their general reputation, it could have been devastating to their standing, as they could have their license revoked. So it was clearly wrong. What is the big deal about this? And you'll see from the papers on your table there that the libel, it's not wrong. It would not be wrong to say lawyers wanted $28,000 an hour. That's not true, but that's not a libel. But to say lawyers charged, that's saying, as a matter of fact, this happened, they did it. That is libelous. The Court of Appeals of North Carolina clearly said that Dan Boyce's law firm, that's Boyce and Isley in 2000, that was the law firm accused in the ad, and that they illegally made excessive charges. And you'll see from the information that we'll show in the PowerPoint, I'm trying to get to it as quick as I can, that the ad, the consultants first wrote the ad different from the telephone push poll. The ad was first written to say, and you see this on the table, Dan Boyce, his law firm wanted, not charged, but wanted $28,000 an hour. That's not libelous. That's greedy, but it's not illegal. It's not a violation of the rules of ethics. It's wrong. The ad, when first written by the consultant, said wanted $28,000 an hour. When the ad came on TV, though, it was changed. It was changed to Dan Boyce, his law firm, sued the state, which was wrong. Wanted, no, not wanted, but charged. The exact wording of the violation of the legal ethical rule is lawyers shall not charge. The Court of Appeals in 2002, way back then, made the ruling that that is libel per se. The ad was published. It was published by the defendants. It's libel per se. The only issues left, they said in 2002, are the ones that I hope you all will participate in and answer what you believe on this evidence. Was the ad false? And the ad definitely, without question, in our minds, and the reason the lawsuit was brought, is patently false. At first, it was not known how the ad came to say that. It was not first known until pretrial discovery got into emails. You know, Richard Nixon made a big mistake. He didn't burn the tapes. The first question when I got back to Raleigh from that little episode, Chief Justice Branch of the North Carolina Supreme Court stopped me on the sidewalk out in front of the Supreme Court building and said, Gene, I got a question. I said, yes, sir. He said, tell me something. I said, why didn't Nixon erase those tapes? That was from the Chief Justice. It would have been, if he'd been caught, he could be prosecuted for destroying evidence. That may have been one reason. The other reason was he never thought they'd be disclosed. But in any event, that's what the situation is. And in this case, for years, we focused on the email that we discovered through the process of pretrial discovery and hours and hours and hours and thousands of hours of work on our part to show that the ad, and we have the original ads, but this was the main one, was marked. It first said Dan Boyce sued the state and wanted. Somebody changed it to Dan Boyce, his firm, sued the state and charged. Made it, somebody used that word and made it legally wrong, legally libel per se, to accuse lawyers of charging an excessive fee. The question naturally comes up in anybody's mind, well, who on earth did that? The consultants typed up the ad, but somebody in their own handwriting changed it from a non-libelous ad to a libelous ad. And it was changed because of the telephone push poll to which people had reacted about the accusation of having charged, lawyers having charged that kind of illegal fee. Well, guess whose handwriting that is? It's Roy Cooper's handwriting. Unbelievably discovered in the process of the pretrial discovery whose handwriting it is, confirmed and verified as to whose handwriting it is, and it tied all the process together. And that is what has been referred to in this case, and you'll see on the PowerPoint. In every case, in every scandal, there's a smoking gun. That was a smoking gun. And that's probably one reason it didn't go to a jury trial. In our estimation, it was an open and shut case of blatant lying for the sole purpose of gaining personal political advantage. Now, we have invited, the door has been open. If there's anybody here who wants the floor to talk about any defense that they can think of to this case, and any reason for it to have gone on for 14 years, raise your hand and you're welcome to come up. In fact, if we'd gone to trial, my first witness would have been Roy Cooper. That'd been easy. Roy, you wrote this ad. Roy, this is your handwriting? Yeah. Is it true or false? I could probably rested the case with one witness. There's just no question about it, because the evidence came from them, not from our suspicions or what we thought may have happened, but from actual written evidence. And it's comparable to what happened to Richard Nixon. You know how that went back and forth for such a long time about Nixon denying it. But when the tapes were played and it had the actual voice recordings of what the people were saying in the Oval Office about obstruction of justice, about trying to get the CIA to tell the FBI to lay off the investigation and by not revealing the truth. The same thing here. It was a question of covering up the truth. I would like now to go to the PowerPoint. Thank you. Excuse me for talking more than you, but I appreciate you. Yeah, thank you for getting me into this. This is hopefully a summary that I'm going to try to finish, and obviously this sort of thing could take a much longer time than we have. And also, if there's anybody who has a 1 o'clock appointment, or don't feel free to leave. That's perfectly okay. We all understand, so don't feel like you have to stay. Let's see, Rich, what I had to push this red button to? One on the row. I can begin. Yeah. This is a quote that I came up with because I believe strongly in it for your benefit and for my benefit. It is an important thing for a person's name and their reputation is maybe more important, but at least equally important to their bank account, to their home, to their children, to their marriage. But a good name is pretty doggone valuable. And that was the point of this litigation, to protect the good name of Boyce and Isley PLLC that was formed in 1999, and this slander happened a year and 4 months later. It was accused of cheating clients. It didn't even have time to cheat clients, much less that being the truth. And this is an important thing that I found in many cases that involve libel, mainly in media cases. You got to remember there's two things in our constitutions about this subject. One is free press and one is free speech. The Cooper crowd, the Cooper lawyers tried to combine the two and make political speech the same as a free press right. The free press right is broader than the individual free speech right. And I'm a strong believer in a free press. The freer the better. But even so, there's no place in democracy for the deliberate lie by anybody, whether it's a newspaper reporter, a TV reporter, or individual. But that's a level of proof that has to be reached when the press does something wrong or a political candidate does something wrong. The person wrong has to prove actual knowledge of falsity, actual falsity, and personal knowledge that it's false. Anybody else, all they got to prove is negligence. And that's a pretty lesser standard. But that is the difference. And Justice Holmes said many years ago, as far as government is concerned, as far as our democracy is concerned, it's our government. We put people up there and we expect them to tell us the truth. We put them there for a purpose, to protect our rights, to do the right thing, and by all means tell us exactly what's going on. We may be having a little trouble about that today. I don't know what you hear on the newscast, but getting the honest, truthful information is not always possible. But that's what the law still requires. A much wiser man, and you've seen this, Nietzsche, I'm not upset that you lied to me. Well, this ad not only lied to me and about us, but it lied to you. And a lie not only is upsetting, but it deprives the liar of credibility. From now on, if you lie once, how can we possibly completely trust you never to lie again? I submit you can't, and so did Friedrich Nietzsche 127 years ago. Sort of goes without saying. And here I mentioned there's the two types of lie. One is a lie, somebody tells a lie to you about something. That's a lie that is told to you. But the other one is a lie that is told about you. This lie was told about me, my family, and our little law firm. It was told about us, but it was told to you. And this may be harder to take than that, but no matter what, it's wrong. First, a lie is told to you. Second is a lie that's told about you. Now, I've spent a lot of time studying the constitutions, and when all this happened, I began to wonder why on earth. Well, I can use my little pointer. Not many people know this. Not many lawyers know this when I talk to them about it. Our article about property rights, it not only says every person for an injury done in his lands, goods, person, it says reputation. Every person for an injury done to him or her in a reputation shall have remedy without favor, denial, or delay. Well, I submit 14 years is a little bit of delay, but still, we have a right, I have a right, you have a right, just like your automobile, your house, your home, your bank account, your property, your goods, your land. You have a right to your reputation not being abused by politicians, third parties, or whoever. Also, not only does the Constitution guarantee you and me and Boyce and Isley that right, it also says freedom of speech and press are two of the greatest bulwarks of liberty. No question about that. Free speech, free press. And shall never be restrained. No, you say anything you want to as long as it's the truth, but every person shall be held responsible for their abuse. So when these political people published a false ad, knowing it to be false, they violated the right of Boyce and Isley and my group to damage to their reputation. And they are responsible for abusing this right. It's clear as it can be, and it's in the Constitution. Not just the General Assembly law, but the state constitution protects that. The U.S. Constitution doesn't mention reputation. Most other states don't mention reputation as being a property right. North Carolina does. And Cooper was told when the ad came out, he was told in writing, the ad is wrong, it is false, and was told why. On Halloween night, it came out on ran for 7 days and nights, October 31st, November 1st, 2nd, 3rd, 4th. The Boyce and Isley wrote him on November the 2nd, the third day, said, Cooper, your ad's a lie, stop it, retract it, it's wrong, and here's why. Judge Manning issued a statement. The judge in the case said it was wrong. So Will Carlisle was a law firm. Boyce and Isley wasn't a law firm. That's wrong. Dan Boyce wasn't involved. Gene Boyce was with Will Carlisle, but Dan Boyce was not. He was told the truth. It was ignored. It was continued to be ignored. And issue number one was, is it a lie? Did Boyce and Isley charge clients $28,000? Not only Boyce and Isley didn't exist, not only didn't charge $28,000, there was no fee whatever in the case because Judge Manning ordered that. And in a class action in the case where the judge says it's not true, you'd think that Roy Cooper and his crowd would believe the judge. Maybe they don't like me. Maybe they wouldn't believe me when we told them it was a lie. But to be sure, when the judge told them the ad was wrong on November the 2nd, to be sure they knew then it was a deliberate lie. The Boyce and Isley was not in the case. It didn't even exist. No fees were charged by anyone. The judge ordered 3 times and was shown in the newspapers, there will be no fees in this case. I think a first grade student in grammar school could understand that statement. There were no fees, so the ad is false. Even the news reports during that week said the Cooper's TV ad is, quote, mistaken. We were told by one reporter that a reporter said his story as he submitted it to the editor said it's false. The editor said, well, let's don't say it's false, let's say it's mistaken. The newspaper came out, it's mistaken. It was a lie. Some of my friends don't jump into conclusions, but some friends have said, Gene, I think it's a GD lie. I said, what are you talking about? I said, yeah, greatly damaging lie. I had to agree with that. So in early October, what precipitated it was that Cooper, and we have the email showing this, Cooper crowd learned that Dan, when they started out in February of 2000, neither Dan nor Roy Cooper were well known. They had about a 15–16% name recognition. As it went on, that grew as the publicity grew, and Roy had a lead for several months of a few points. He was a well-known state legislator. Dan was a lawyer in Raleigh, didn't have any statewide presence, but Roy led 3 or 4 or 5 percentage points. But in early October, a poll came out. We saw it, and it was in the Cooper crowd's emails. They saw it. Dan had taken the lead, 42% to 41%. We have the emails. Cooper's political campaign reaction to losing the lead. We have to hit Dan Boyce and hit him soon. What is the type of person that would have to say we got to hit somebody, we got to lie about them, we got to attack them? Cooper's hometown newspaper, we have the article in which Cooper said, I was so proud, in effect, I was so proud of myself, I didn't engage in any negative advertising when I ran for the state House and Senate. Yeah, well. But the headline said, Coop goes for the juggler. And he went for the Boyce and Isley and our juggler. And Cooper's told by his research people, political research, the only way we get to your opponent, Dan Boyce, is through his dad. because his dad was with Will Carlisle. That was the firm that was involved in the ad. Still no fees, but it was a lie that Boyce and Isley was involved. So does Cooper know the ad is false? That's the second issue you'll have before you. Cooper himself, he was a client of ours, of me and Will Carlisle. He was a class action. He got 2 full refunds, no fees. All of the data has been destroyed pursuant to Judge Manning's orders, but I've got all the names and addresses of at least 172,000 co-plaintiffs, and there's not a one of them that would testify or say there was any fee, whatever charged. It was all profit from the refunds. Cooper was also a member of the 19 legislative class. He voted to refund the taxpayers. He voted to refund himself. He was on the Revenue Laws Committee of the State Senate. He knew what was going on. He had full knowledge of all the facts of the law, and the Cooper family, and others had clients, and his lawyers that continued to say the ad is true. Some of them were clients of mine, and they know that nobody paid any fee. All good lawyers, and I put that in parentheses because maybe all of them don't know, but only a judge could charge a fee in a class action case. Once it becomes a class action case, the judge takes full authority over it. Lawyers can't even charge, much less $28,000. They can't charge $1 in fees because that's the responsibility of the judge under the law, that the judge controls that class of people. I knew Mike and Chris and them. I knew a handful of taxpayers, but I didn't know all 172,000 people that I was working for, that I did work for, that I represented, that I won the case for. I didn't know but a handful of them. But my thought all along was if I screw up, I can get sued by 172,000 people for malpractice. That occurred to me once or twice, so I stayed up late working on it. But in any event, Cooper, in this case, he had 4 big law firms were on the other side. He had 14 lawyers on the other side, and this case went on for 14 years. Well, somebody said, Gene, said, what are you fussing about? 14 lawyers and you? That's pretty even. I appreciate it. Not true, but I appreciated the joke, the compliment. All courts say this is the law of the case. This was a ruling going back to 2002 and 2006. The words of political ad, no question about what the words are. No question about demeaning a person's profession, trade, or business is libel in and of itself. Damages are presumed when it's libel per se, slander per se. If it's that bad, there's some damage, and it's just up to the jury to say whether it's $1 or $100, $1,000, or whatever. But Cooper cannot deny. It was published, no question about it, and how often it was published. His accusations are of and concerning the plaintiffs. The court held that, say, Dan Boyce's law firm in 2000 referred to Dan Boyce's law firm, Boyce and Isley. Cooper's purpose and his gist and thrust, the court said the gist and thrust of this ad is exactly what I would assume you all conclude, is to make the other side look like a bunch of crooks, especially not just the opponent, but the opponent through his father is an unethical lawyer. The latest decision, the last decision we got, the Court of Appeals said it was a zinger of a political ad. I thought that was a pretty good word for them to use. It was a zinger. It zinged. And defaming a person's business is an unfair trade practice. Damages to victims of libel per se are presumed. There's no question about it. Somebody asked me, said, Gene, why did you stay in this case? Why did you push it? This lawsuit that we're talking about here that would go to trial and your issues you can answer the way you honestly feel about it. It was one effort on the part of my family, my law firm, my son, my daughter, my son-in-law, to restore our name, to protect what we thought we had a good name and ought to retain it. It was done through the civil lawsuit. It could have been done in the criminal court. As I told you, it's a crime. It's a crime under the statute to publish a false political ad. Since 1937, it's been a crime. Well, what else did we do to try to end it? Not still talking about it 14 years later. We presented it to the Board of Elections. presented the evidence. We didn't have all this background evidence at that time, but right after it ran in December, it went to the Board of Elections. The Board of Elections came out with an opinion and said, well, that's politics, so what? Larry Leake was then chairman of the Board of Elections. After all that happened, we wondered, why did they take this so lightly? It's pretty serious. Guess what? Larry Leake, chairman of the Board of Elections, ruled in Cooper's favor. Top campaign contributor to Roy Cooper. Sponsor of an Asheville fundraiser, raised, I think, $37,000 for Roy Cooper. He presided over that hearing and wrote that opinion. After that was done, the other two members, there were 2 Democrats and 2 Republican members, I wrote them when I found out later on. I didn't know it at the time, but 6 months after, when I got looking into it, staying up late at night, I found that Leake had that on the record, that he was did he tell anybody? He didn't tell us when the hearing. He didn't say, I have a possible conflict of interest, which is the right thing to do. I wrote the 2 Democrats and the 2 Republicans a letter. I said, did you people know that your chairman, when he and you all ruled and saying Boyce and Isley had no reason to complain about this political ad, did you know he was a contributor and a fundraiser? The 2 Republicans wrote back almost by return mail, said, no, we didn't know that. He didn't tell us. He didn't disclose his conflict to his own board members. Didn't hear from the 2 Democratic members of the committee for a while. I wrote him a second letter. I said, I've written you, I need to know, did Mr. Leake reveal to you that he was a Cooper top contributor, $400,000 I think it was, and a fundraiser in Asheville that I found out? Did he reveal that to you when you all were ruling on the Boyce and Isley petition? And I didn't get an answer. Still didn't get an answer. You know the oak tree, the little nut that doesn't give up? Okay. I wrote a third letter. I said, would you folks please give me a suitable date where I can take your deposition under oath and ask you these questions? Almost immediately, I got a response. One of them had been appointed a district court judge. They immediately, after about 3 months of effort on my part, wrote back and said, no, we didn't know. That was an effort that went down the drain. One bad thing about this accusation that happened in November of 2000 on TV, it continued on through the 14 years of the lawsuit, because the lawsuit, in the answer that Cooper and his lawyers filed, it said, first affirmative defense, the political ad is true. The political ad is true. Boyce and Isley charged the state $28,000 an hour. They repeated the libel in the courthouse records. They filed an amended answer in which the first affirmative defense was the political ad is true. Later on, they filed a second amended answer. For the third time, Cooper and his people and their lawyers signed documents saying the political ad is true. The falsehood, the slander, the libel continued for 14 years. Well, that's bad enough. But this old oak tree knows that those documents are permanent. They're in writing. They're in the court records in Wake County, the Court of Appeals, the State Supreme Court, and Washington, D.C. has records in which 14 lawyers and 4 big law firms have repeated the libel, the political ad is true. Now, I've gotten over the anger. I haven't gotten over the disappointment, but one thing I have not and will not get over is doing anything I can so it doesn't happen to somebody like me again, so it doesn't happen to you. Something's got to be done to teach political people, political consultants, people who want a job, people who want a stepping stone to higher office, people who want to have control of 200 employees, people who want a free health plan, salary. Don't lie to win that office. Don't lie to get people to give you that privilege. You've got to tell the truth. So it's a violation of every law, and without forwarding too forward to Sunday morning, it is also a violation of the 9th commandment. Thou shalt not bear false witness. That's probably the biggest reason that any of us, I think, could come up with. The heck with lawsuits, damages, politics. Do not bear false witness. And what you will be presented with, and Alec, would you mind handing this? This is a jury sheet that would have gone to a jury in Wake County. What they would have answered, I don't know. We would love to have your opinions, for or against, and you can write on the back any comments you have. It will be helpful to us to know what other people, independent, you'll probably lean in our direction because you're here before the John Locke Society, which I think the world of and have tried to support through the years because they think the right thing and do the right thing. But Roy had the smoking gun. He pulled the trigger, and he made the ad slanderous. That is a violation of the state bar rules. He changed it himself. This is his own email right here. You've got copies of that. One thing about this, we noticed when we found out it was his handwriting, we focused on that. Let me let you focus on something else. The ad was supposed to say, he said, I'm Roy Cooper, candidate for Attorney General, and I sponsored this ad. Look what the consultants had for him to say originally. I'm Roy Cooper, candidate for Attorney General, and I sponsored this ad because I want you to know the truth. Those 8 words were dropped on the television ad. Why? Maybe he didn't want you to know the truth. I don't know. But that's what it smells like. So how long did he continue? This has to do with the damage that's done to people. Like the lady in the store where one person hears the slander, that's damage. But how many people, this was the push poll where it was 800 people, not 500. And 80% of them said it would make a difference of how I'd vote. This is about what he first said. I sponsored this ad. Now look at what he first wrote for him to say, I sponsored that because I want you to know the truth. He didn't want you to know the truth. You were a victim of political slander, left and right. Now, what does it all mean in the scheme of things when you have a salute like this? How many people heard the ad? That's a point of proof as to the extent of damage. The law says damages are, some amount of damages are presumed. It's up to the jury to decide. The law also says that punitive damages can be awarded. But so what was Cooper's intent? What did he hope happened in order to win office for himself? 7 days and nights he broadcast this ad. 7 days and nights. So we heard it. How many people could see and hear the ad? How many homes had a TV set in 2000 that the ad went to from 15 or so television stations? So how many people were exposed to this falsehood, to this blatant lie accusing lawyers of violating their rules of ethics? We had 30 TV stations. I think at least half of them carried the ad. In 2000, I got these statistics from the U.S. Census Bureau. We had over 8 million people back then. It's up to 10 million now, but of these, this meant 3,797,000 households. Of the households, the statistics from the Census Bureau show 92% of people in North Carolina and 90% of the nation have at least one TV set. And of the population in North Carolina, 6 million of them are voting age. So Cooper was sending this libelous ad to these people. The libelous ad also went outside the state. We had relatives, our in-laws in Virginia, and up and sat down in South Carolina because what in the world's going on? One interesting thing is when Dan's wife Betty heard the ad on the ad that Boyce and Isley charged $28,000 an hour, she called him and said, Dan, where's all that money? I think she said, where's all that damn money? But it was not just a little thing. It was very widespread. And here in Wake County, where we have friends and acquaintances and neighbors and clients, there's almost 700,000 people in 2000 that were neighbors and friends and acquaintances, and there were 235,000 Raleigh houses that had at least one TV set. This doesn't include the bars and the taverns and the hospitals and the facilities with TV sets. This is just the home. So that many people had access to this on their TV. So he wanted 525,000 people of voting age of my neighbors to elect him Attorney General based on telling them that Dan Boyce, his firm of lawyers, I mean, there's no question, nobody would vote for a lawyer or a lawyer's son or anybody else that did something. And Cooper said, I'm the honest answer. I'm the honest candidate. I don't think so. Anyway, so what's the damage when somebody does that to you, to one person? That's damage. When they do it to a house full of people. Right now, when it's done on the internet, oh man, you've got millions of people worldwide hearing, seeing a libelous advertisement. So for 7 days and nights, 3 times a day, on at least half of the TV stations, we say Cooper wanted 6 million people to believe Dan Boyce and his law firm cheated the clients. For what reason? Totally selfish motivation to vote for him, give him a job, give him a stepping stone to higher office, give him a staff of 200 people, give him all the prestige of high political office. So people could see it 3 times a day on TV for 7 days and nights. That's just each time, that's 21 times. Well, it went on half the stations, 21 times on 15 stations. That's 315 libels. That's just to the station. Statement was sent to that many homes. Cooper's broadcast went 11 million times, if my math is correct, 11,960,550 possible times. You could never prove how many people actually saw the ad. That's beside the point. It's what Cooper and his group intended to happen. So he spent $1 million for the possibility of 11,960 TV times on TV and going out to the public. That was 11 million times on to 630,000 registered voters of voting age in North Carolina at that time. So his potential media reach, that's what the consultants called it. What do the advertisers won't disclose? And his $1 million ad paid for by his wealthy donors, and I've got a list of them, PACs, he had a lot of PACs, and had a whole bunch of uninformed voters. But this was the number of attempts to exhibit and publish that lie throughout the state of North Carolina. 72,190,560. I can't say that many times it was published, but he intended, and his media consultants intended to let their $1 million at least try to go out to that many people. And not counted are the 14 years of repetition by 14 lawyers, 4 big law firms, 1 DC law firm, 3 North Carolina, that keep saying the political ad is true. Well, I'm here to say now, and will say forever, the ad is blatantly, totally false. There's no question about it, but you, the jury, tell me. And if there's anybody here from Roy Cooper who wants to floor, they said they wrote me Thursday and warned me not to say anything that was marked confidential. I haven't said anything that was marked confidential. In fact, everything I have told you, I said in 2012 to the United States Supreme Court. I told them what the truth was, and this is a copy of what I filed. And the main thing I filed with them was the smoking gun. Roy's statement, his handwriting, changing the ad. For the second time, the U.S. Supreme Court ruled in our favor. Everything I've told you about these emails is public record in the U.S. Supreme Court. So that phone call last week, that email last week doesn't bother me one bit. If they want to sue me, okay, I can defend myself. And so you, the jury, are entitled to two issues. Is Cooper ad's false in saying that Boyce and Houser charged clients $28,000 an hour? We say absolutely. And did Cooper personally know what he was saying was false? We say the evidence is overwhelming, but you're the jury. You decide on your own. Mark it. If you think we're wrong, we'd like to know. And also, I meant to finish long before now. I'm sorry, but I'd be glad to take any questions that you may have. Punitive damages. The reason for punitive damages is statute. North Carolina statute says punitive damages may be awarded to punish the defendant. punishment for somebody doing something wrong is pretty nice. But it also says it's also to punish for egregious and to deter the defendant and others from committing similar wrongful acts. One reason I lasted in this was to let a jury say to the public what people think, not what I think, but what Dan or Philip or Laura, but what people think. How wrong do they think it is by a punitive damage amount of money, whether it's $10, $100, whatever. People, a jury is the conscience of the community. Surely you are the conscience of a group of people that like the John Locke Society, that like freedom, that like the Constitution, that espouse those political thoughts. But you are the conscience of the community. What you speak is not what I say, but what I can prove. So thank you very much for your kind attention, gracious attention. And also on behalf of the folks here, thank you for supporting the John Locke Foundation.